Come on in, we're watching the Kohberger trial.
So it's essentially allowing the state to prove something, a very important fact in this case, simply by asserting that the term touch DNA is usable or acceptable in the forensic community. We presented at least three sources that say, and these are reputable people who are publishing in reputable journals, saying that this type of language is misleading, and it can lead to a misunderstanding of the evidence itself, because touch DNA does not mean now that someone touched something. It simply means that in some mechanism, DNA from a person has gotten to an object, whether that's through direct or indirect contact.
I assume your expert's going to tell the jury all that.
I'm sorry?
Test the mic.
Tell the jury all that.
Yes, and Miss Nolan will be telling the jury that as well as she testifies.
What are we worried about?
What we're worried about
Thank you,
is
Cheryl.
using to the
Y'all can hear me through the
layperson
mic?
to hear an expert use a term that is essentially a description of activity. I'm not very good at grammar, but I believe that's an adverb. And it is not one that is useful for a jury, and it will be misleading because ultimately the experts will be discussing a much broader source of what we might call contact or touch DNA, which is anything that comes from a human being, including saliva or blood. Just because you don't see it, just because you can't see a blood stain doesn't mean it's not that stain, or that area that is sampled doesn't have some other biological fluid. So it's very misleading. And it's just not necessary. And there's a paper that was presented as a human factors report that was published last year, where the consensus, although there were two dissenters, is that analysts should not be using this kind of language and not proffering, and this goes to the next question, not proffering opinions about this, but that the language itself is extremely misleading. There are other ways to talk about it. Ms. Nolan rejects the term trace. That was just one expert's opinion in one article that was cited to the court, but it's very clear she doesn't need to use that term in her description of how DNA moves in the environment. So we would ask the court to prohibit her or any other witness, frankly, from using those terms in describing any DNA sample that's been collected in this case. As far as Ms. Nolan's opinion, again, it goes hand in hand with this idea that touch DNA or the contact DNA is not what it used to be thought of. And there's a number of publications, scientific journals, where the scientists have reviewed vast quantities of scientific literature. I think I counted up over 300 articles in the two, were reviewed by the two articles that were cited in the moving papers that say that there is really no way for a particular analyst in a particular lab to determine how and when DNA was placed on an object when you don't have any facts behind it. In other words, unless you see something or you know something, you have facts of the method of transfer, it's not possible. So first of all, Ms. Nolan is not qualified to offer such an opinion. It's very clear from the growing consensus in the community that transfer in and of itself, how things get places, is a separate expertise, which requires separate training. And a DNA analyst working in a laboratory does not have that kind of training. And in fact, it's not really provided in the United States. There is a paradigm in Europe that is being used, but it's not been accepted or used here in the United States at this point, which is the concern from some of the experts who were on the human factors report. But Ms. Nolan is not at all qualified. If you review her CV, which was part of, I think, the first disclosure in December of last year, going through the list of courses that she's attended, none of them are specific to transfer. And in her affidavit that was supplied to the court, she discusses attending some presentations at a recent meeting where there was discussion of transfer, where some unnamed individuals disagree with this idea that it's not something that should be testified to. But I think there's that her presentation, and this is what the court has to consider, the facts presented by the state in support of their opinion, is not supported by anything other than this vague statement, well, some people don't agree with this position. We don't know who those people are. The state and Ms. Nolan have presented no particular scientific articles that support her opinion. And she has presented no specific training to take her from an expert around DNA testing, which no one is suggesting she is not, to an expert on the how and the when of transfer in this particular case. Then
this
when you
lady's
look at her
long-winded.
opinion, I think the court has to exclude it because it's highly speculative and it's incredibly confusing. She first states that the consensus in the community is that you cannot determine when and how DNA moves onto a particular object. She says that without any qualifications, that the science doesn't support that. She then proceeds to say the DNA on the sheath could have gotten there through indirect transfer, meaning it was not placed there by direct contact of a hand, for instance, with the object. And then she goes on to say, but because of two facts, the quantity and the fact there's a single source, I believe it got there through direct contact. She offers this court absolutely no information to support that. She doesn't.
Other than those two things.
I'm sorry?
Other than those two things.
Well, yes, those are two facts, but those facts and the meaning of the facts are relevant. We cited a number of cases that talk about expert witnesses and speculative opinions. And our position is that this opinion is so speculative and so confusing that it shouldn't be presented to the jury, in great part because Ms. Nolan does not present this court with anything to support her conclusion. She's basically saying the science says I can't do this, but I think I can. If we were in a different place where we had some articles to support her conclusion, if there were articles to support the fact that the amount of DNA or the fact that it's a single source sample is probative of that the scientific principles and methods of DNA testing support that, then we'd be in a different place. But that's not where we are. We're here with a naked opinion with no foundational facts to support it, other than Ms. Nolan's training and experience. And while training and experience is a relevant consideration for this court, we don't even know what training and what experience she's relying on. We don't have any indication that the lab has done any studies internally about this question. We don't know what literature she's been reading. And frankly, even though she attended this meeting that was held in February, where the proceedings are online and available, she didn't bother to let the court know who spoke and what they said. So I think the reason is because she doesn't have any support for this. And it's going to be incredibly time-consuming, not only to cross-examine her, but to present evidence to rebut her opinion. And given the speculative nature and the sort of both sides of it nature, I think the court has to exclude it.
You are I'll start where she left off. I don't think she's accurately characterizing what the opinion that's been disclosed. Ms. Nolan did not say, I agree that the science says you should not opine on this or that you cannot opine on this. All she says is that the science does say you can't conclusively establish it. But there are factors, she lays out a lot of those factors that you can look at to decide, to indicate how it ended up there. And she's very forthright. She says, look, it's possible that this was secondary transfer, but based on the fact that it's single source and the amount that was transferred, in my opinion, it was primary. I think under the Idaho Supreme Court's test for expert testimony, that passes. She's acknowledging the limitations and she's giving her opinion, which is going to assist the jury in reaching their conclusion, because the jury's not familiar with any of these factors that she's laying out for them. So, and then as to this idea that she's not qualified, so Ms. Nolan, as disclosed, has been at the ISP lab for 2 decades. She's a forensic scientist. She specializes in biology and DNA. For the last 10 years, she's been the lab manager and overseeing all of the biology and DNA. That includes instructing, as indicated in her CV, law enforcement and others on the collection of DNA. What we're discussing is a critical component of all of that, which is how does DNA get from one place to another? She has plenty of experience to talk about that while admitting that she can't conclusively say one way or the other. But as laid out in the brief, that's never been the test for expert testimony, that you have to be able to say with scientific certainty that this is in fact the case. Now, on the issue of the touch DNA and just the label itself, I don't know that I've ever litigated a case where a party has come in and moved to exclude a phrase used by their own expert in their report. And she didn't just use it, she used it specifically in reference to the DNA on the knife sheath, the exact same way that our expert would use it. And now you have an attorney before the court. She used to be an expert in this case, but now she's an attorney saying, well, you shouldn't do that. You shouldn't, even though both the experts in this case use that phrase, the court should step in and say, you're not allowed to use this phrase that's commonly used in your field because it might mislead the jury.
Kohberger is looking unfazed.
Whatever risk there is of misleading by the phrase touch DNA is easily dealt with on cross-examination. There's a definition that Ms. Nolan provides for that. I assume, though it's not given, that the defense's expert has a definition for that, and they can explain what they mean by that. I don't think it's outside the bounds or intellectual capacity of a juror to understand that sometimes in particular professional fields, there are phrases used that may not mean exactly what they sound like. I think we can expect jurors to understand that and to understand the fuller meaning that's given to it. Part of the problem with the defense's motion at this stage is by asking this court to limit not only our expert, but their own expert, they're admitting that there's something there to be cross-examined. And so if this court orders there can be no statement or no mention of touch DNA, then I think that cuts off a very legitimate line of cross-examination from the state.
So I'm not particularly fond in general of proscribing phrases and words that can be used by parties and witnesses in cases. I think it just creates the potential that you're going to have problems because people slip, and particularly when you're using phrases and words that are commonly used within the field, right? We see that all the time with the use of the term victim, right, in cases, and the Supreme Court has recently weighed in on that issue. And there's actually an instruction that deals with the use of the term victim, because it's just, it's hard to police phraseology. On the other hand, if what we're talking about is an agreement that, this term may be implying something that we all agreed isn't necessarily true in all cases. I mean, we could call it blueberry DNA for all that matters, right? And your experts are going to explain what it means otherwise. What's the concern here if we say, let's try not to call it this? Other than accidental violation, and now somebody's asking for a mistrial, right? I mean, that's one of my concerns.
So in reality, that's really the state's only concern is we don't want to get in a situation where there's a word that's off limit. And because She uses it, the defense expert uses it, it slips out at one point that suddenly we have a motion for a mistrial because there was a violation of this court's order. As defense counsel mentioned, Ms. Nolan didn't rely on this word heavily much at all in her opinion, and I don't anticipate her testimony to be anything different. But if at one point in the back and forth, either with us or with the defense attorney, she slips and says the touch DNA on the knife sheath, I don't think that that's a problem. And I don't think that it's something that this court should restrict. I think both of these experts felt comfortable and wanted to use that phrase. That's why they used it. I don't think it's superfluous. I don't think they just said touch to say touch. I think to them it means something, and it's accurate to use it in this case with respect to the sheath. But certainly the state has no problem encouraging Ms. Nolan to avoid that word to the extent it's possible.
Thank you.
Thanks, Your Honor.
Just a quick response. Language is important, and language in science evolves and changes. Ms. Nolan and Dr. Ballard, our expert, are scientists. They present themselves as experts. And I think that scientists should be held to a slightly different standard than the average witness. And the use of language, as this court pointed out to me early on when I first stood up here, is really important. And I am confident that Ms. Nolan can restrain herself from using that language. And I'm confident that all of the parties can ask questions that do not elicit that kind of information or use those words. And I would encourage the court to restrict the use of those words for this proceeding. As far as Ms. Nolan's opinion, no one is asking for certainty. Nobody expects scientific certainty. That is not our position. The question is it supported by the science that Ms. Nolan is essentially testifying about? And the answer to that is no. Her personal opinion is not science. It is a personal opinion. And if the
You're relying on a scientific report to which there were dissenters.
Yes, but the dissent was not about the content of the recommendation. The dissent was, we don't have any options, and maybe we shouldn't be requiring trainings that are not particularly available in the United States. That is the nature of the dissent. And
But in support of the idea that this testimony shouldn't be precluded by these people.
I'm sorry, I couldn't.
But in support of the dissent, in support of
Yes.
opposition to a scientific consensus that this testimony should not be presented.
That's correct, but I don't think that the court has to rely on a 100% consensus of the community. I think that the evolving understanding of the science and the scientists in this area and of the people who are actually publishing work is highly relevant to whether or not that kind of opinion is actually acceptable anymore. And I suppose that the question of admissibility might revolve around a more like a Daubert standard. But given that we have not had the opportunity to see these opinions until so recently, that was not something we were able to do.
Yeah, the Supreme Court has specifically rejected the Daubert standard.
Well, I'm new to Idaho law, Your Honor. That's why I suggest Daubert. But that kind of analysis, I think, is the same type of analysis that this court has to do, as sort of essentially a gatekeeper to make sure the jury is hearing reliable evidence. And I think that if you read closely, in particular, Ms. Nolan's second disclosure, which I believe came out in February, or was given to the court in February, she lays out a whole series of things that affect transfer. She makes one statement about the quantity of DNA being higher with direct transfer, but that's not elucidated in any way, and doesn't talk in anywhere in that disclosure or any other disclosure why a single source profile would support her contention. And I think because of the complex nature of this, that we can't speculate as to why. It may make logical sense, but I'm not sure it makes scientific sense to speculate, which I think is what we are prone to do. And as I think the Idaho courts have said, the court's not supposed to substitute its judgment when for the expert's opinion, but to consider it in the context in which it's presented. And here, there is nothing to support her opinion, absent her assertion of training and experience. I'll stop with that.
Right. I'm going to take under advisement the issue of Ms. Nolan's testimony about her conclusion of the likelihood of direct contact of the DNA. As to the use of the term touch DNA, I'm not going to preclude it. As I indicated, I think it's a discretionary matter. There's science in that area uses the term to have a particular meaning. That meaning can be explained to the jury through the experts. In addition, much as the term victim, there's an instruction for, I'm not opposed to giving an instruction to the jury should that term come out, that the court is not intending to, by use of that term or by any of the attorneys' use of that term, making a conclusion. On the other hand, I do encourage the parties to not use the term as much as they can. I think we underestimate the intelligence and reasonableness of jurors, having presided over, I don't know, well over 100 jury trials. I think that we worry about things that they are more than competent to understand and not jump to a conclusion simply by the use of a word, particularly where there's scientific testimony around explaining what that word means in context. And so I'm not particularly worried about it. I'm not opposed to some kind of instructions if the parties can agree on one. I would suggest the parties come to an understanding of what a term they should, as a council at least, try to use. I'm not going to try to police the experts within their own field who use that term as part of their expertise, as both experts did, state and defense in this case. But certainly would encourage council to try to avoid it as much as possible.
Avoid the word
All right,
touch
now, I think
DNA.
we're on the make and model of the suspect vehicle.
Enjoy your seatbelt.
Your Honor, this is a motion
What?
where the words do matter. We're following up on that one. This seems appropriate. This motion, we're talking about the phrase used by the state, suspect vehicle number 1. First, this motion is grounded in Mr. Kohberger's rights to due process and a fair trial. Thinking of why we have this motion, we have to remember this is a highly circumstantial case. That's what this case is about. And one of the pieces of circumstantial evidence that the state will use is a video from a house on King Road, 1112 King Road. And that video depicts a vehicle. There are several views of that video with vehicles in it. The state will also use other videos that depict vehicles or a vehicle in surrounding areas. As they said in their response briefing, they do not have one continuous video loop. So the state's piecing together several videos and calling them all suspect vehicle number 1. That invades the province of the jury to make that determination. The state has Special Agent Immel, who will testify and identify a make and model of a vehicle from one of the many clips of videos that the state will use. That make and model cannot be identified from other than one view of that. This motion is not asking the court to prohibit the state from producing the videos or producing Agent Immel insofar as his testimony matches his expert disclosure. But this is about preventing the state from saying, this is suspect vehicle number 1. This is the same vehicle in all of these video clips. That's something that the jury will have to decide after they hear evidence to make that determination. This motion is important because that has been referred to, suspect vehicle number 1 has been referred to by the state in their affidavits for search warrants and other pleadings that they've written where the state has made this connection and they can't do that. This is up to the jury to make the connection if this vehicle in 1112 King is the same one that was in 1125 Ridge Road and other various places that the state intends to show. We're asking the court for an order prohibiting the state from making the reference of this as suspect vehicle 1 to state that as a fact, not to prevent them from presenting evidence in the way of video clips or expert testimony, but just to prevent them from invading the jury box when that's up to the jury to decide if that's the same vehicle, if it's a Hyundai Elantra, and if it's consistent with one that Mr. Kohberger drove at some point.
That's interesting. Did you guys know about the video clips? And that he could only be identified in one of them for sure?
Your Honor, it is our expert opinion, who is a vehicle identification specialist, Anthony Imel. It is his opinion that the suspect vehicle captured on various surveillance video shares similar class characteristics to a 2014 to 2015 Hyundai Elantra. He specifically relied on certain video, while some are better views than others, but he relied on all video from 451 Paradise, 1125 Ridge Road, 1112 King Road, and all the WSU surveillance to come up to his opinion. His opinion is based on logical inferences of review of the surveillance footage, including observed traffic flow, the time of night, the direction of travel, and the camera timestamps. The jury should be allowed to hear his opinion, weigh that information with other testimony and other admitted evidence, and decide if they believe that that vehicle is a 2014-2015 white Hyundai Elantra. Of course, the defense will have the opportunity to cross-examine S.A. Imel. That's the process, and that's the process that should happen. There are no legal grounds to exclude this opinion or to limit it. Thank you.
Okay, Cassie, I don't know how do you say your name? Wow.
Our
A lot going
request
on here.
is not at this stage to limit Agent Immel's opinion that's consistent with the timely disclosed report. It's our request to have an order from the court preventing the state from referring to the vehicle as one vehicle in all of these clips. Agent Immel can talk about the clips, we can view the clips with the jury, and he'll be subject to cross-examination. The motion is wholly about.
We'll say that this is the same vehicle on each of the clips, that
No.
his expertise.
No, I think he'll testify that it could be consistent. I think he'll testify he could only identify a Hyundai Elantra from the 1125 Ridge Road video. And I think that he will agree that his original opinion was that it was a 2011 to 2013 Hyundai Elantra. And I think he'll testify that only after Mr. Kohberger was identified.
It's not actually true. As I understand it, it was expanded before the 19th.
Let me back up. The email that I think was disclosed in the Frank's motion to the court was that he preferred a 2011 to 2013 Hyundai Elantra, but open up the search through 2016. Moscow Police Department set out their Be on the Lookout flyer for a 2011 to 13 Elantra, and that's what was sought for a long time. Agent Immel in that email did say expand that year. The change that there's a vehicle, a Hyundai Elantra that's a 2014 to 2016 came later, and that came after Mr. Kohberger was identified on December 19th, and in looking at WSU footage of a different vehicle. That's putting a vehicle together much later after Mr. Kohberger's been identified, not back in November of 2022 when they're trying to identify a vehicle.
I don't think that's consistent with the facts, but okay. I think the facts are in the email. It was originally, let's look at this date range. And then he said, well, you know, I'm more comfortable with an expanded, or we need to expand the range through 2015. And that was well before Mr. Kohberger was identified. Now, what BOLA went out, I don't know. I think it may have gone out in 2 different forms at one point, but the opinion that it could be was before that time, at least as evidenced in the emails.
I agree that in that email, he said expand the search to 2016, but he was more comfortable with a certain year.
Okay, so
That's, I'm trying to explain to the court where I'm coming to my request to the court. I was asked what Agent Immel would say, and I'm repeating it to the very best of my ability. The motion is not about Agent Immel's testimony. I will be able to cross-examine him. He can talk about the videos. He can talk about moments in time where he made certain identifications and why he said what he said in emails. I can talk to him about when the focus for 2014 to 16 changed. What I'm talking about in this motion, what I'm asking the court to exclude is the prosecutor from standing up and telling the jury that this is the same vehicle all the way through these videos.
that would violate what I said earlier about argument before closing. They may say in opening, the testimony of the FBI specialist you will hear is that this is the vehicle that is seen on the various surveillance cameras. That's different.
I agree. The phrasing the prosecutor has used for a long time in this case is to call the vehicle suspect vehicle 1. And so that's the purpose of the motion. This is my opportunity to ask the court for an order, and that's what I'm doing. Thank you.
She's getting frustrated.
Right. So I'm going to write a little something on this issue, but what's that? Did the state not respond? That was rebuttal, wasn't
They're trying to get phrases and everything excluded.
it?
Touch DNA and everything.
I tracked there. My inclination is certainly the state should not be making conclusions outside of closing statement. I don't think calling the vehicle suspect vehicle 1 is making a specific conclusion. It's again using a term that is used within the investigation, but specifically making an argument that the various vehicles or the various images of vehicles on the various surveillance cameras is the same vehicle. Making that conclusion is an argument, and so that wouldn't be appropriate. I think in opening, for example, you can say that the testimony will be right. As to the agent's ability to make that conclusion, I don't believe that that is an ultimate opinion of that is taking the ultimate conclusion from the jury. I think that's right
It's
within the
maybe
province of
ish.
expertise, and I don't believe, based on the evidence, that it is speculative, such that the agent shouldn't be allowed to offer that testimony. But I will write up further my analysis on that. All right. With that, let's take a lunch break, about 45, 50 minutes, and then we will come back. We'll shortly before 1, but no later than 1.
All rise.
Okay, so what is happening here? We'll take the lunch break with them, but just to recap, this was a trial. They started off arguing about different phrases that you can and can't use, and the whatnots. So I'm going to go take the break with them. And we'll come back. Meet me back here at 3 p.m. Eastern Standard Time, okay? Thank you, guys. I'll see you in just a little bit.